I said one.
Just counted. Nobody says one when they do the countdown, but
I was
you.
off. I was off on my.
That doesn't make any sense.
This is not a professional organization.
We're not winging it. We know we got lots of people here. This is professional.
You're right.
We have a whole team of people.
You're right. You're right.
We got a whole organization.
Sure.
All right. There are people that handle all of us.
We'll let people believe that.
Yeah, well, let people believe it's true.
Well, it is what it is.
It is what it is. Last night, I had the fortunate experience of going to a listening party for Rochelle Gemini. It was pretty dope. I'm sad that you missed it.
Yeah, I hurt my foot. I hurt my foot. I'm at the point now where, I'm 40, so.
Oh shit.
Yeah. I'm 40, so I hurt my foot. It happened after the gym. Can I attribute it to the gym? I don't know. Like, I was good when I left. I woke up in the morning. My foot was hurting. It gradually got worse during the day. It's been horrible yesterday. It was horrible today, but it's getting better. But it's that old thing. Like, I don't even know. Like, I can't call a doctor on this. Like, he's going to be like, you're old. So it is what it is.
At least you know.
Yeah, I put an ice pack on it. It was fine.
That's what you called me about the
ice. That's why I called you about the ice pack. Like, yo, throw an ice pack in the freezer.
That is a positive thing. At least he knows he looks good for his age. Yeah. A lot of you didn't know he was 40. That's because black don't crack. But unlike me, black and ugly as ever, have I stayed Houston down to my socks. In my humble opinion podcast, we are back, ladies and gentlemen. I'm one of your hosts, Avery, like a very nice guy. You can find me on all socials as Avery Zadius. It's how it's spelled. If you find me, you find me. If you don't, you don't. But we have my brother, my co-host with me, Jess Devon on Twitter and Dr. Douglas on Instagram. How you doing, Devon?
I'm good. Same handle, same, Jess Devon. It is what it is.
Same number, same hood. It's all good. I quote a lot of Biggie. For him not to be my favorite rapper because Scarface is the greatest rapper of all time.
And Scarface is such a good rapper, people don't even include him.
Exactly.
And when you put him up against Biggie, people go, "Oh, well,
they all get quiet."
Oh, okay.
You've seen it. Every time I bring it up, people be like, "You got a point there." I'll be like, "Better storytelling." I was like, it makes better sense. But we could talk about that all day. We don't need to talk about that all day because you can find us on My Humble O on Instagram and on Twitter. And we're also on, what's this thing that we're on right now? Oh, YouTube. We're on YouTube. You can look at our ugly mugs every day, but we have...
We're on Facebook for the older people, too. I think Dad watches us on Facebook.
I keep on forgetting I only use Facebook. Only
mom might watch us on. Older people watch us on Facebook. I forget every once in a while. I upload to Facebook every week, and every once in a while it'll be like, you have 10 new likes. I'm like, on what?
Nigga. I don't get on Facebook unless I have to get in touch.
If it's good enough for LeVar Ball, it's good enough for us.
Wow. Wait, LeVar Ball's on Facebook? Never mind. We'll talk about that.
He has a whole show on Facebook.
He does? I don't know any of this stuff.
Never lost.
He never lost. And you know how you never lose? You have to have a right team of people with you, just like we have. That includes managers. That includes sometimes trainers. And a lot of times that includes lawyers. Now, what we have today is somebody who actually does intellectual property law. Now, I got to be honest with you. Okay, Devon went to law school, all right? Okay, I have no idea what this is, all right? So intellectual property, all right, is property categorized of property that includes intangible creations of the human intellect. What does that mean? What we're going to do is we're going to find out what this means with our guest today, all right? Our guest today, actually, trademark lawyer. Okay, she does copyright and also a business attorney. She has, you said, 250 trademarks that you've done, and most of them have gone through, correct?
Yeah, most of them have gotten registered.
Oh, yes, that's awesome.
High registration rate.
That's awesome. So that means she knows what she's talking about. that's one of the most positive things that we're going to get to today. Also, like I said, reading straight from her Instagram, I see that she's a beginner golfer. We talked about that a little bit. I thought maybe she was trash because I'm looking at just the pictures. No, she's not at all. So we have with us today Jordan B. Franklin, Esquire, ladies and gentlemen, who's going to explain to us copyrights.
Everything copyright.
Yes.
That's good. That's good. How are you doing today?
I'm great. How are y'all?
We're doing wonderful.
We are good. We are good. I have been waiting because he always does these intricate intros, but I've been waiting for this because I was like, I don't know if he knows what trademark is, so this is going to be interesting. I thought you handled it well.
I know very little. I know about it, you know the words, but like
I get that.
I need to know everything there is to know because I mean you hear a lot of people talk about when it comes to trademarking and the new things out right now, NFTs and things of that nature. So I'm going to sit here and really try to find out what actually can be trademarked.
And that's why we have Miss Franklin here, because I think a lot of people, like everybody knows trademark, everybody knows copyright, and then you're like, okay, but what does that mean specifically?
Yeah.
And they go, if you just put like an R in the corner, like that's it. And you get these weird myths, like yes.
Don't mail shit to yourself. It doesn't copyright anything.
Look, everybody loves to say, hey, if you burn your album on a CD and then you mail it to yourself certified, copyright done. And I was like,
no,
that doesn't feel real. That doesn't feel real at all.
That doesn't work. See, I'm learning. Wait, that doesn't work for real.
No. It really does not work. No. It is not doing anything.
Where did that come from?
Urban myths. You know how you play telephone? Somebody's probably like, hey, you need to mail your application in to the copyright office and then you get a registration. And they probably went from that to, oh, if you mail it to yourself, you get a copyright registration. I'm like, no, it's not right at all.
Now, we're going to talk about all these myths and get into copyright, get into trademark. But first, we need to just talk about you. You have I think you got a great story about persevering and getting through and making sure that you accomplish your goal. You started out headed towards the medical path.
Yeah,
absolutely.
Okay, so you started out, and I'm just going to be honest with you. I, too, also started out towards the medical path. I stopped because I realized people got blood inside of them. It's not that I didn't know that.
That's why it didn't bother me. I didn't have
the blood bothered me. The amount of blood is what bothered me. I was like, yo, I'm out. So what was it that got you off the path?
Whew, man. So I went to Baylor for undergrad, and Baylor has probably one of the largest like medical schools in Houston. Mm-hmm. So, most people go to Baylor with the whole premise of becoming a doctor at some point. So I really wanted to be a plastic and reconstructive surgeon. And I wanted to volunteer with this organization called Operation Smile. And they're plastic and reconstructive surgeons that do normally some type of facial reconstruction for children in third world countries, like fixed cleft palates and stuff like that. So that's what I wanted to do. I got to genetics. I said, woo, God, I know this is not what you have for me. This ain't it. This is not it. And it's so crazy because I love to tell this story now because my best friend to this day, who was my roommate at the time, we had genetics together. So the way Baylor does it is you either go on a bio route or chemistry route. And so if you go bio route, you basically knock all your bios out first. If you go chemistry route, you knock all your chemistries out first. I already knew me and chemistry didn't get along too well. But, I took like the AP bios and like, I love biology in high school. So I was like, I'm going to go the bio route. Man, I got to genetics. I said, whoo, nah, this can't be it. So she used to come in my room every morning and like bust in the room, get up, we gotta go. And I'm just like, you gotta get out of my face. She used to be so excited. We be sitting right next to each other and she's writing notes. I'm sitting here like this, I'm online shopping, and I'm the type of person that loves to learn. So when I started losing my desire, I was like, something is not right. So that's when I was like, okay, I need to explore like other avenues. What is it that I'm passionate about? So Baylor also requires you to take political science. And that was my first time reading a case and having to argue on the affirmative. A professor would assign you either you on the affirmative or the defense, depending on whatever case there is. That was my first time reading a case and actually arguing it, because I didn't do debate and stuff like that in high school. So that opened my eyes and I was like, yo, I like this. Fast forward, that same roommate now is getting ready to start her residency in anesthesiology. So it worked out for her. It worked out for her. Shout out to my best friend, Dee, Dr. Dee, as we call her now. So, you know, and she got into one of the top anesthesiology residency programs here in the state of Texas. So I'm super proud of her. But yeah, so God called her for that, not me.
Okay.
That's what definitely deterred me over. I said, yeah, I'm not even gonna make it to chemistry. So I'm like, what's next?
God sent your roommate towards that path.
Oh yeah, that was her calling.
At what point? So you went on the path towards law. Like after you're in this political science class, you're like, yo, I like this. I got a knack for this. And then you had to just readjust and you got to take the LSAT and all that other kind of stuff. How does your path go forward then?
It was rough. So I took the LSAT. One, I have really bad test anxiety. I've never been really good at standardized testing. How standardized testing versus like regular testing differs for me is because, as y'all know, a standardized test is not actually testing your knowledge.
Not at all.
So it's not testing your knowledge. When it came to anything knowledge based, I was blowing out the water. I've never failed a class. So it's like, I'm not stupid. But for some reason, it's like standardized testing. It never went well for me. So the LSAT was a bit of a struggle. I wasn't really getting the score that I liked. For the LSAT, they score you on a scale between 120 and 180. I wanted to be ideally in the higher 150s to 160s. That's a great score. You get more scholarships, all of those things. I couldn't get past about a 148. That's the highest that I scored. So it was a little rough. I was like, you know what, I'm going to apply anyway. I think I applied to 18 law schools and all of them but 2 rejected me.
Oh, wow.
Yeah, it was very, what's the word I'm looking for?
Sobering?
Discouraging. It's very discouraging. And I'm like super, super, super grounded in my faith. And I remember having a conversation with my pastor one Sunday. I attend the Lighthouse Church here in Houston. So yeah, I started my ministry and stuff. So I've known Pastor Keon since the church was small. Like we were meeting in high school. Yeah. So I was just like down in the dumps one Sunday. He was like, Jay, what's wrong? I couldn't even get it out without crying. He was like, come here. So we kind of like walked off to the side. And he was like, we about to pray right now. So we prayed. And when we finished, I was getting ready to walk out. And he was like, it's going to be the last school you apply to that you get into. I was like, I ain't got it in me to apply to no more schools. I'm tired. I'm tired of hearing no.
No more rejection.
Yeah, I'm tired. Like, you know, it really kills your self-esteem a lot. And I've always been the type of person to excel. And I'm just like, I'm not even asking for anything but an opportunity. I don't even want scholarships at this point. Just let me get in and let me show you what I can do.
Yeah.
So I went home and I applied to Southern. That was the last school I applied to. At that point, I didn't even know Southern had a law school. Somebody had brought it up in conversation like earlier that week. So I was like, all right, I'm gonna go apply to Southern. Because at this point I hadn't heard from TSU because I'm born and raised in Houston. So I applied to TSU as well. So in 2 weeks, Southern sent me an acceptance package. And then of course, like a week before school started, TSU was like, congratulations. I was like, get out of here. I didn't already move to Baton Rouge.
Get out of here, Thurgood.
At that point, I had moved to Baton Rouge. I had paid my security deposit, my seat deposit. I was buying books. I was like, where was y'all at? Where was y'all at 3 months ago?
I love my HBCUs, but I feel like everybody that applied to multiple ones always has a story of like, on day one, the one I wanted sent me a message like, hey, where you at? Like, we got everything here for you. I'm like, I'm in another state.
I'm gone now. I'll say that it was a blessing in disguise because I think it would have been super distracting for me to stay here in Houston.
Okay.
All my friends were here. All my family is here. And my family families. You know what I'm saying? Like they don't understand. Oh, so you're not gonna come in here and be social with the family. I have to study.
I'm feeling you.
Exams. What? Like, so I think it was definitely a blessing in disguise because I didn't have the element of distraction. 1, 2, I feel like God places you in places of isolation to elevate you. So I was out in Baton Rouge by myself. I didn't know anyone. I have family in Louisiana. My dad is from like Monroe and Gilbert, so that's northern Louisiana. But when my great grandfather passed, I didn't really know any family up there like that. He was like the last piece of family that I knew. So it's not like I was about to go up there and visit people. I don't know y'all. So I was essentially by myself outside of the friends and stuff I made. And I will humbly say that I was able to show my ass for 3 years in a great way. And I absolutely felt like had I gone anywhere else, I wouldn't have been able to do that. Southern really gave me an opportunity to spread my wings and to leave a legacy. Like I got a chance to be student government president for the law school my last year. But with that privilege as well came the opportunity to sit on the board of trustees for the entire university system. And everybody else outside of me was appointed by the governor. So it was, I'm really rubbing elbows with some people, and I wasn't just on the board, I was a voting member on the board. So I really got a chance to have a voice on behalf of the students. And I am as loving as I can be, but when it comes to a duty being bestowed upon me, I'm very aggressive. So there were situations to where students were getting the short end of the stick in some things, of course, like with any university, and I was extremely loud. And it was to the point where they had to listen and make decisions that better fit the students. So I was really grateful about that opportunity. And then meeting people who were from the schools that rejected me, like when they realized who I was, it was just like, damn. But at that point, it's like, I appreciate your denial because it put me exactly where I needed to be.
No, that's perfect. That's perfect. The other thing too is as you're there now, when you went to law school, was going in, were you like, I want to get into trademarking? I know you have the high interest in fashion law, and getting into that. Was that your goal from jump, or did you just get there and then figure that out?
So it was not. When I initially went into law school, I wanted to be a sports agent.
Okay.
And the reason being is because the guy I dated all through college played professional basketball. And I would just hear like his agent, and I'm like, that's stupid. Like, why would you go? I'm just like, oh no. So I was like,
I do a better job than you.
Yeah, and I was like, that was my man at the time. So I'm like really protective. We don't accept that figure. Y'all can come better. Like how many men 6'10" that can shoot threes like a point guard? Like come on. I'm just like, you gotta come better. He was like, okay, you're a little aggressive. He was like, maybe you should be an agent. I said, you know what? You're right. Granted, we're not together anymore, but we're still like really good friends. So I initially thought I wanted to be a sports agent. Got into school, took sports law, and was like, oh no, this is not it either. Like this is not at all what I thought. Especially, I'm not sure if y'all know who Nicole Lynn is. She probably doesn't even remember this conversation. And if she hears this podcast, I just want to thank her because this was right around the time she was getting started. And she knows a lot of the same people I know. My cousins are actually her neos. They all went to Oklahoma, University of Oklahoma together.
Really?
So I got her contact information and I called her and was like, hey, I'm a first year in law school. I'm thinking about being a sports agent. I know you're already on that path. Like, what are your thoughts? She gave me the real. I ended that phone conversation thankful for her, but also realizing, okay, I got time to figure out something else because I don't want to get So what class was it that did it for me? I think I took an intellectual property class. So to go back to your earlier question, intellectual property is an umbrella term that we use to encompass primarily 3 areas of law, and that's trademarks, that is copyrights, and that are patents as well.
Okay.
And kind of like in the definition you gave, they're basically property that becomes something tangible as a result of what you cook up in your head, your thoughts, your ideas. And when it becomes something tangible, that's when one of the 3 areas will then attach. So I was like, okay, this is dope. So I started getting more into it. And I was like, okay, I like this. I love art. I always have. I said I didn't do debate in high school because all my time was in the performing arts wing. I almost did not leave that wing of the school. I started playing classical piano when I was 6. I joined orchestra when I was 11. And did that all through high school, like played symphonic music and, 5-piece movements. And my private lesson teacher is the principal clarinetist for the Houston Symphony. And like all of the, like that was my childhood. I was in musical theater. The very first musical I ever did was The Wiz, because that was also my favorite musical of all time. I grew up listening to The Wiz. So like my freshman year when I saw they were having auditions, I said, oh, this is a no-brainer. I got to do. So my life has been art in some form or fashion, and intellectual property law is the area of law that directly impacts artists in some form or fashion. So I was like, I know I don't want to be a professional musician, but this is my way to still be able to contribute to the arts community.
Okay.
That's not bad. That's not bad.
Wait, before we move on though, did you you auditioned for The Wiz? Did you get it?
So let me tell you about that because I still hold a grudge.
Okay.
One of my best friends, like him and I became really close. There's rarely people that I still talk to in high school, but he's one of those people because we met during the Wiz auditions. So I made it. The only role I auditioned for was Glinda, the good witch.
The good witch.
So Lena Horne played her in the movie. So I was like, this is my role. This is me.
Gotta be like Lena.
I was like, this role was made for me. And I didn't cut my hair until college. So my hair was probably about shoulder length. I was like, you ain't even got to put a wig on me. Like, I'm ready to go. I was taking voice lessons at that time. So I sing pretty well. I'm like, let's do it. So we made it down to the wire. It's the last 2 standing. It's me and a senior. And the head of like choral performance or whatever, basically the choir director, pulls me aside and he was like, I'm going to let you know now that we're going to give the role to Alexis. I said, what you mean you're going to give the role to Alexis? Shouldn't it be whoever earns the role? He was like, well, yeah, but she's a senior. There are scouts actually looking at her. If you're a freshman, you have time. So I ended up being the understudy. I was like, oh, no, y'all should have gave me the role. I was pissed. I was like, oh, she break her ankle. So I can get out there. So I ended up being like, basically a chorus member, like when they go to Oz and it's like, I have to be seen green. Yeah. So I was like some bullshit, but
I mean, I can see the energy on you. I'm sorry.
That was my first brush with like theater politics because I was like, I don't care if scouts are looking at her. Like, what?
I got the skills.
Yeah, so it kind of left a bad taste in my mouth. So I actually didn't audition for any plays my sophomore or my junior year. And this same best friend of mine, and same thing happened to him. He auditioned for The Lion. And they understudied him for The Lion too, because of a senior. And we were both like, this is what we're doing, right? So senior year, he was like, we're doing Godspell. I'm not sure if y'all are familiar with that play. It's basically like a modern twist on the story of Jesus and the 12 disciples.
Okay.
But the disciples are a combination of women and men. Each disciple has a song. So it's a smaller cast. There is no chorus. It's the person who plays Jesus, and it's the 12 disciples, including the person who plays Judas. Yeah. Everybody has like their own solo. Like it was like smaller cast. So I was like, I don't know. Even though I am a senior this year, I don't want to deal with it. You know, I haven't really been in the theater scene for 2 years at this point. They don't really know who I am. He was like, just audition. So I ended up getting one of the disciple roles, which was like pretty dope. So I at least got a chance to leave my senior year with a solo position. And we got nominated for, they call them Tony Toon Awards.
Yeah.
And it's basically like the high school equivalent of Tonys. Tommy Toons. It's the high school equivalent of Tonys.
Oh, Tommy Toon, that's clever.
Yeah. So our high school, actually for Godspell, got nominated. We got nominated for a lot during the Wiz. We got nominated for some for Godspell as well. So I got a chance to like go to that. And we always got beat by the white schools because I went to a predominantly Black high school, even though our choreography was always better, our orchestra was always tighter, but you know how that goes. So
I mean, we've all seen that movie.
The politics.
We know what it is.
Yeah. An immense passion. So I can understand why you would go into trademark in order to, help out your passion, which was art.
Yeah, I love it. And that's why I like fashion, because fashion to me is walking art on the human body.
Okay.
I love museums. Like when I studied abroad in Europe, I think the best part of my trip was the Louvre is so large in Paris, you pretty much have to break it up in a few days. So we were in Paris for like 3-4 days. 2 of those days we spent at the Louvre, and I was just in like awe because I love classical art too, classical Italian art to be exact. So I was just like, this blew my mind. My favorite sculpture, we didn't get a chance to see it, but it's the Pieta by Michelangelo, and that's in the Sistine Chapel.
Oh,
so
no.
It was like just being around all of that, I was like super giddy.
Yeah.
So it's all like he was saying, your goal now is protecting that passion for a lot of these artists, a lot of these creatives. You get out of law school, and did you just start up your own firm? Did you?
Once I finally got over the bar exam, I did.
Oh, well, of course, it's a bar.
That was a hurdle in and of itself.
Well, you know what? I'm gonna say everybody got. A lot of people do not know about the bar exam. So, I mean, just let people know.
That exam is rough. In Texas, it's a 15-hour exam that they break up in 3 days, 3 back-to-back days, Tuesday, Wednesday, Thursday.
And you know what? I'm also going to stop you because you went to school in Louisiana.
I did.
So Louisiana has Napoleonic Code, which is way different than everywhere else. Like
all 49 other states have a different.
Hold on. So the
Louisiana French.
Okay, so for the listeners and for me, what exactly is this bar exam?
So it's the lawyer's licensing exam. You know, nurses have the NCLEX, and doctors take STEP. CPAs take the what is the CPA exam called? I can't think of it. But whatever, it's like the licensing.
They take it though. So the licensing exam.
Yeah.
And what separated the licensing exam in Louisiana specifically? You guys said Napoleonic Code. What is that?
So Louisiana is the only state that practices civil law as opposed to common law. And civil law is based on, them being colonized by France prior to us purchasing them during the Louisiana Purchase. So they're the only state out of 50 that practices that type of law. So when I came back to Texas, you only have a little over 2 months to study for the bar exam. So I had 2 months to learn 3 years worth of Texas law. Now that I put it that way, I didn't do too bad. I ended up failing it by 9 points the first time that I took it.
Okay.
That exam is so emotionally exhausting. Like that period was to me worse than the trials that I went through with the LSAT because the bar completely shattered my confidence that I had in myself. I was like legit depressed.
I can understand.
The only thing that really pulled, and like I will say a lot of law students go through it because the second you step foot in law school, they drill in your head that you have to pass the bar on the first time for whatever reason. I don't know why. And that's something that has been, I feel like, a personal mission of mine to break, is the stigma that you have to pass on the first time. That does not make you a better lawyer. When I found out that my forever first lady, Michelle Obama, had to take the bar twice, I was like, okay, you know, clearly you're in elite company when you take the bar exam more than one time. But at the time, you don't see that. You see failure, and it feels like it. And so it's really hard to not take that failure personally. And I know I'm not the only law student that does it that did it, because I try to pride myself on helping pull people out of that place. Because I was in it for a while, and my problem was I shut people out. So I didn't allow my circle. I'm one of the people who like to grieve in private, and grieve in isolation. So I had friends who wanted to be there. You know, my boyfriend at the time wanted to be there. My family wanted to be there. And I just pushed everybody out. I'm like, y'all don't understand. Ain't nobody studying with me. You know, for the bar, you study almost 12 hours a day, every day for 2 months. Like, you go freaking crazy studying law all day, every day. And it's all law that you're never going to practice most of the time. Like, it's constitutional law, criminal law, family law. Like, I don't practice that, but you have to learn all of it. So it was mental warfare for a while. And I had a hard time pulling myself out of that. So I graduated in 2017. I didn't pass the bar until 2018. I just, mentally, I couldn't get it right. So after the second time I failed it, I just took a moment, and I'm like, okay, you want to do this on your own, or do you want to let God in? What is your option? What you gonna do? So I was like, clearly I'm failing doing this by myself. I was like, I gotta remove me and let God do what he needs to do. So that's the best decision I ever made. And I passed it by almost 100 points.
Oh, wow. Okay. So once you pass and your confidence is back up, I mean, did you immediately say I'm just gonna start my own firm and start working and start doing trademarking?
I did it out of necessity. Most firms I found, until the one I'm at now, did not have any separation when it came to intellectual property law. You had to be able to do patents, trademarks, and copyrights. I have zero interest in patents. And the thing about patents as well is, because they're so technical, so patents protect inventions primarily. So because of that, to practice patent law, you have to have either a hard science, computer science, or engineering undergrad degree. I do not have that. My undergrad degree is in philosophy. I have a double minor in religion and European history. Ain't nowhere near hard science. I took every liberal arts class I could take. Granted, like I told y'all at the beginning, you know, I started on the hard science route. I started with the bios and the pre-meds. So there's really only a few more classes that I would need to take to have the hard science requirement that I need. But I'm not going back to school for that. So I was like, I have no interest in it anyway. So I had a hard time finding a job that would hire me without the hard science background. I knew it was possible because I had a mentor at the time who worked for a fairly large firm who did trademark work. He introduced me to trademarks. While I was in law school, I kind of like interned for him remotely, but his degree was in journalism. So I'm like, I know there's a way. I'll figure it out. You know, we're from the South. They always say it's more than one way to skin a cat. So I was like, I'm gonna figure it out. So I was like, you know what? I have enough of a following. I can use social media. I'm gonna just wing this thing and see what I can do on my own. And it blew up way bigger than I, you know, at the time really could handle. So people always ask, well, why'd you leave your firm and go to another firm? It was a blessing, but I outgrew myself too fast. And I didn't have the means or the resources that I needed alone for the level of clientele that I was getting and the workload that I had. So I was like, I need to make a shift somehow.
And that's one of the things we kind of noticed, your handling of social media really well,
Yeah.
talking about trademark issues and copyright issues that were happening in real time. And you see an attorney that's giving out, I mean, just basically giving out general advice every time something comes up. And then eventually, under these tweets, you see people like, man, I need a trademark. I need this. I need that. You know, uh, let's get into just some of the trademarking things. One, and this is just from looking at your feed, so I kind of know the answer already. But for our audience, when should you get a trademark? Wait, I'm sorry. What is a trademark?
Yes.
And then when should you get it?
So I like to work backwards. When should you get it? As soon as possible. What do trademarks cover? Trademarks cover what I like to narrow down to as your branding. So under the law, trademarks were invented. So all intellectual property law dates back to the founding of the Constitution. It's all listed in there. The way that they describe it, I want to say it's Article 3 of the Constitution is where intellectual property is discussed. But trademarks were invented to prevent consumer confusion in the marketplace. Mm. So they protect the way that a consumer identifies your brand and connects it with whatever you do or sell. So that is your name, that is logos, that is slogans or taglines. And nowadays, a lot of people turning their slogans and taglines into hashtags. So all of that is under trademark protection. And then the bigger the brand is, that is colors, that is sounds, and that is smells. So when people are like, you can trademark a smell, baby lotion.
Really?
You already know what that smells like just because I said it.
You're right. You're right.
That's a trademark. That's a trademark scent. Play-Doh. Play-Doh is a trademark scent. It's like, because you as a consumer, all you need to do is, if somebody put it on a smell stick and put it under your nose, you'd be like, oh, that's baby lotion. Boom. Right. Trademark. Right. It's, you know, and as far as colors go, when you see Robin's Egg Blue, what brand do you think about?
What, Tiffany?
Yep. So it's Tiffany Blue, but that is a registered trademark. Post-it note yellow.
Wow.
That is a registered trademark. Home Depot orange.
I remember there was a case about
Christian Lieutenant is red.
Yeah. I don't know where that went.
Oh, he ended up winning.
Oh, wow.
Yeah, because that case is what opened my eyes to the fact that there was a lane for fashion law. Oh, fashion and where fashion and trademarks coincide. Because Christian Louboutin was actually suing Yves Saint Laurent because they attempted to come out with a red monochromatic heel that had a red sole. Well, two things are looked at under the law when you're trying to see if there is a competing brand that is likely to cause confusion in the marketplace. They look at the similarity of the marks themselves. And in this case, it was the color. And then two, the goods or services connected. So it's high fashion women's shoes. So it's like, well, who used it first? Who is it most associated with? If you see a red sole, you're not thinking, wow, her YSLs are bomb. You're thinking she got them Lulus. You know what I'm saying? So that was him being able to say, we've used this for decades. It's ours. And they were like, you know what? You're right. You win. And it's a Spark Note version because way more than that. But, you know, I don't want to get like overly legal and technical, but that's essentially how that went. And why he was able to be like, this is our thing. Like, if y'all was wanting to come out with red soles, you should have thought about that. But now it's a little too late because it's a huge moniker of our brand.
Interesting. And you know what? I mean, you brought up, I mean, especially with the internet and the way things trend. I'm thinking about that, I guess recently, the gentleman that was like, where the money reside. And as he was blowing up, you immediately saw him, like, people were like, hey, get an attorney, like, right now.
Yeah. I will say, for like content creators or creatives, period. And this is more so with our people. People can say what they want, but Black people are trendy. All these trends that happen in popular culture, 9.9 times out of 10 stem from something either we do or say, we wear, and then it becomes trendy. Where we mess up is we don't move as fast as Darrell did, and we don't get a chance to capitalize off of it. Brands like a Forever 21 or someone will come in, and then all of a sudden they start making checks and profits off of the things that we made popular. So I applaud him. I actually know that the attorney that he's working with, she's a Black woman, and she is freaking phenomenal. And they hopped on that so quick to where you didn't have any choice but to be like, all right, like we gotta respect it. He's building this as a brand.
I mean, I think one of the biggest things is when you're with somebody like Darrell, and it's great that he moved quick. I feel like he's seen and learned lessons from like I think about the young lady that said on fleek.
Yeah, I was thinking about her too.
Yeah, and it's one of those things where it's like I said it and it's out there, but like, can I really do anything with this? And then it gets popped, and then the next thing you know, it's just a word and it's out there. And so it is a thing where it's like, if I'm a content creator, or even if I'm not a content creator, if I just said something that went viral, at what point and what's the process of going and getting a trademark or a copyright or anything to protect myself against it? Because I think a lot of people are just like, I don't really know what I'm supposed to do with this.
Yeah, that's actually a phenomenal question. Because just saying it is not enough. When you file for a trademark, you have to file it in what the law calls a class. I think they're better understood as categories. Each of these categories, and there's 46, represent either a type of good sold or a type of service that's provided. So when you file a trademark, you have to file it in one of these 46 classes. What he did, and usually what the first and the fastest class to file in is anything that deals with apparel. So that's t-shirts, that's socks, caps, things that people would try to print it on quickly. Well, apparel is normally going to be the first thing that people try to print something on fast that has gone viral. So that is normally the first category you should at least apply to. But here's the kicker. A lot of people don't know that there are two different types of applications. So in a situation like Darrell's, what he did was filed an intent to use application. And that sounds like what it is. He doesn't have any tangible products he can submit to the USPTO to show that he's using it. But you file this application and it can block any later filed applications after yours. And what it's telling the trademark office is something is coming. I'm still in the process of figuring out exactly what I'm gonna print out or whatnot. But let me go ahead and jump start my place in this trademark processing line, which would allow me to block anybody from coming after me, even if I don't have anything tangible to prove that I'm using it yet. So an intent to use application buys you some time to go ahead and start producing shirts or whatever that is. So that's what he did, which is like super smart. And I think they filed in a few different categories. Financially, that can be pricey because each category has a $250 filing fee. Mm-hmm. So the more you file in, the higher that filing fee is going to be. I think they filed in 3, so that's that's a $750 filing fee. But he filed in stuff like entertainment-based services, the apparel piece, stuff that like makes sense that you would think you can easily make money off of. That's where you would need to file. And then if you file it, like I said, as an intent to use, it can buy you some time to actually develop those products to then prove to the trademark office, hey, I'm using it. This is how I'm using it. And you can get the registration.
And I guess even with that, I mean, I think about, because we were talking about apparel, I remember reading about 50 Cent when he had G Unit and he made, it wasn't like a big deal. It was like a little blurb in an article, but he was just talking about, I took a whole lot of money to pay for an international trademark because he's like, a lot of people don't know. Like, he's like, you can trademark it here and it's not everywhere else. And he goes, it paid for a lot because we had to fight a lot of people on G Unit around the world. So can you speak on that? That because we're talking about the U.S. Patent Office and international.
So you always have to file in your home country first. And the reason being is because I'm trying to not get too legally technical. So if I do, let me know. But the US is a part of different agreements with foreign countries when it comes to intellectual property rights. Every major country or group of countries has like their own type of filing system. So the EU has a filing system. The EU used to contain 28 member countries until the UK left. Yeah. So now the UK has their own separate filing system. Central America has one. South America has one. Turkey has one. Russia has one. China has one. China is by itself. Japan is by itself. And then the way Africa is split up, it's a few different kind of groups within Africa itself. So the way these treaties or these agreements work is when you file in your home country and then you select a foreign system to file in, your date of priority dates back to your home country. So let's say, just for the sake of example, for G Unit, he filed in the US in 2004 and then decided to go file in China because China is normally where most of these issues happen. So
yeah.
Let me tell you, last year, New Balance won a 16-year-long trademark infringement lawsuit against a Chinese company. And the company, the company had the sneakers that they used for the lawsuit were gray and they had NBs on the side. I mean, they had an N on the side. Now I was like, no, wait a minute. Their name was like, instead of New Balance, it was like New Bronze. And I was like, what? And China let them get a registration. So New Balance had to go through a 16-year lawsuit to get that registration revoked. So China is normally the country that most people have issues with infringement activity in. Same thing with high fashion. China does most counterfeiting.
Yeah, how does China get that off? Because like here, it's like McDonald's, the M here, and then China can be like, we got McDonald's, and they just get it off. How does that happen?
They're hard to, for whatever reason, hard to regulate, and then they'll choose their infringers over your rights any day. And then you're in a situation like New Balance. New Balance ain't no scrub brand, and they had to fight for 16 years to be like, yo, this is ours. What do you mean? Everybody knows an N on the side of a sneaker is New Balance. Like Nike doesn't even use N's on the side of their shoe. Like what? The shoe even looked, it's a mess. But so back to my example, if 50 Cent filed here in 2003, and then he goes over to China and files in 2005, his date of priority would date back to 2003 because he filed in his home country first. So that's essentially like, so that means if anybody, let's say somebody in China filed in 2004, and then somebody else in China filed 2 months before he did in 2005, his date of priority would leapfrog both of them. So a lot of times in trademarks, it's on a first to file basis, especially in the US. So having those dates of priority can allow you to leapfrog somebody, even if you come over after they have already filed, but your date of priority in your home country predates theirs, if that makes sense. Mm-hmm. So there are ways for you to file in foreign countries. It's normally selecting which ones because everyone has a different filing fee. So that's how that price can get really, really expensive. Normally, I recommend at least starting with the EU because that covers more countries at one time than like Central America or Russia or something like that. And then if you can't afford China, but China also likes to give like US based brands a hard time, clearly. Yeah. So yeah, that's pretty much how like the international piece would work. But that is something that I recommend, especially smaller brands, to look into, but be aware of what you may need to budget for.
And I guess the other thing about that, because you bring up that New Balance case, is just filing the trademark is one thing. You have to have somebody to defend these things going down the line. So, because I mean, like I said, New Balance is not a small company, and it's not like this other company back down when you're like, hey, I got a trademark. I'm obviously New Balance. And they're like, well, we're New Bronze. So
we're Chinese and this is our home turf. It's like, what?
So when you talk about that, it's like when we're looking at hiring an attorney, you want to hire an attorney. I'm assuming that is one going to handle the trademark stuff, but then what about that back end piece of who is going to defend my trademark or my copyright or my patent?
This is where some vetting will need to be done. And I tell my clients this: I have no problem if you want to go and shop around, because the choice of an attorney is a personal choice. Here's what I mean by vet, because I know trademark attorneys who only can file the application, which is some bullshit. Excuse my language. Because the application is the easy piece. You need to know trademark law to be able to first make sure it's a good application. The reason why I have such a high registration rate is because I will tell you before I file it, this is not going to get registered, and let me tell you why. And then I'm not going to file it because I also don't believe in taking money just for the sake of taking money. I have turned down people because I'm telling you, you're not going to be able to get a registration. You may get a cease and desist letter because these brands already exist. They have similar names. If it's almost not going to be worth the headache, especially if it's a situation where, they're wanting to come on an intent to use basis. So you haven't launched yet. You have time to think before you go ahead and file, because once you file and it's out there, like I said, a bigger brand may send you a cease and desist letter and tell you to withdraw the application. You're not getting that filing feedback. It's non-refundable. I'm cheap. I don't believe in wasting money. So I'm not going to file it. But I have some colleagues that I know who have a misconception that trademark lawyers all we do is file applications, which is wrong. Our work starts before the application is even filed. The most important step is to do a very, very detailed search of the trademark office to see whether or not there's a brand already filed. Remember I said it's on a first to file basis. A brand that already has filed that may be too similar to your name. There's another common misconception. When people do self-searches, they'll search their exact name and be like, well, I didn't see anything. Spelling variations can be a problem. Synonyms can be a problem. If there's more than one word present in a name or a phrase, the different order of words can be a problem. Language translations can be a problem. Like all of these things that people who are not aware of trademark law don't even realize. Because all the law says, if two marks are confusingly similar, two keywords, confusingly similar, not confusingly the exact same. The words only need to be similar. So if your word is too similar to someone's brand that already exists, you may have a problem. And not only that, I said you have to file in a class that represents either a good or service that you perform under the brand name or category. So they look at two things when they determine if there's a likelihood of confusion: the similarity in the names and how related the services are. They don't have to be the exact same either. So you filing in a different category won't necessarily help you either. So you have to have a solid foundation and understanding of trademark law itself. We're just talking about before the application process even starts. So a lot of lawyers think the trademarks are quick money, and they get in a situation to where they file an application, they get a response from the trademark office, normally some sort of rejection, and they don't know what the fuck to do. Excuse my language again. And I have been in situations to where I have had colleagues be like, yo, I filed this application. I got a response from the trademark office. They're rejecting it. I don't even know what the rejection means. Can you look at it? And then I'll look at it and it's like, you shouldn't have filed this trademark to begin with, because there's so many different factors. Like every name you want is not trademarkable. If your name is what they consider generic, you can't get a trademark for that. If your name is what they consider descriptive, in other words, if your name gives away what you provide, like service-wise, you can't get a trademark for a name that's considered merely descriptive. An example for that is I had a brand come to me, and they were a construction company that primarily repaired sidewalks. Their name was like New York Sidewalk Repair. Guess what? You repair sidewalks. That's descriptive. You can't get a trademark for that. So a lot of people don't realize that everything you want to file is not trademarkable. I understand the law very well, so I can tell you that from the beginning. Even on an initial call, what brand name? What are your services? Okay, you're not going to be able to get a trademark, and let me tell you why. I can tell you that off the top of my head.
Okay. So I want to start a t-shirt, a motivational t-shirt company called Let's Do It.
It's called what?
Let's Do It.
That's not descriptive. It may be taken, but because it's kind of common.
Yeah.
But it wouldn't be considered descriptive because saying "let's do it" doesn't automatically trigger you sell shirts.
Okay.
So it's not descriptive.
So Nike wouldn't mess with me. Just do it. Let's do it.
Oh, Nike would, but I'm from the trademark perspective. No, yeah, Nike gonna come after you all the time. Anything that's too close. Nike's aggressive. Adidas is even more aggressive. If you got 4 stripes, Adidas is sending you cease and desist.
Really?
You got 2 stripes, you out of there. Like what? Adidas is aggressive.
What about if I have a burger company called McDowell's? Because like,
well, that's textbook infringement. Right? You not having them sesame seeds on your bun is not.
That's not it.
We actually they use that example in law school all the time about it being textbook infringement because the names are still similar. Their symbolisms are similar. Yeah, he may say he has arches and not arcs. I mean, he has arcs and not arches, but from this, the eye, they look the same. And then the fact that technically they would both be filed in the same category with restaurant services.
Yeah.
Trademark infringement.
Well, I mean, and sometimes people get caught up on like, you hear urban legends look, near our grandparents' house out by 5th Ward. I don't know if it's still there. Remember Dairy Dream?
Yes.
Yeah.
So Dairy Dream, which was a Dairy Queen that stopped paying the franchise stuff. And, I think people took it as, oh, they won. But I was like, no, I think Dairy Queen just said, die, whatever, and left it alone.
So if a brand chooses to be like, whatever, that's their prerogative. But I think a lot of people don't realize that every trademark also, let's say you make it through the USPTO examining attorney. You don't get any rejections, no merely descriptive, no likelihood of confusion, none of that. Somehow they let you go through. Every trademark has to go through what's called an opposition period. And that sounds like what it is. I tell my clients, this is the part at the wedding where the pastor says, if anybody objects to this union, speak now or forever hold thy peace. That is the same situation. If anybody has an issue, if they feel like the trademark examining attorney made a mistake, your brand is too similar to theirs, they have a legal right to oppose and block you from getting registered. Every mark goes through it. Now the the opposition period is a 30-day window. So it's a small window. 9 times out of 10, if you don't have an attorney, you're not going to know like where to oppose, when to oppose, how to oppose. You're not going to know any of this stuff. So the window is small. You have 30 days. You can extend it, but you have only, if you don't extend within that 30 days, you can't extend. And then you can only extend for another 30 days. So every single trademark goes through opposition when it's filed. So if a bigger brand catches wind and you may be a little too close for comfort, they can oppose you. And what happens in an opposition is now basically a lawsuit initiates. And this is where, kind of going back to the whole premise of this question, this is where a lot of attorneys fold. So a lot of them fold before, if you get a response from the trademark office, they don't even know how to respond to it. Most responses are preliminary. So they give you an opportunity to make the corrections, submit arguments, submit evidence, whatever, to overcome whatever this preliminary rejection is, to then move the application forward. And then if you get to opposition and this basically lawsuit initiates, that's where more attorneys are even weeded out. If you don't have a strong sense of like litigation background, you're not going to know how to defend or even bring an opposition because it's like being in court. So, I mean, I say not all trademark attorneys are made equal. As nice as I can put that. That's really a big thing for me and my learning, and I learn every day, all day, is that I wanted to be the attorney for my clients to handle everything from beginning to end. And that included, if necessary, being on the defense or on the offense for anything to protect their brand. So I am actually licensed in federal court. I do have litigation experience. Most of the time, any oppositions that I have been involved in, I've been savvy enough to get on the phone with the attorney for the other side and have it settled in a way that's conducive for both parties before a full-blown lawsuit initiates, because that takes years. And I tend to represent a lot smaller brands. So not only does that process take years of you waiting for a trademark, it gets expensive. So what is a way that I can still accomplish what my client wants to? We may have to make a few adjustments, but as long as it's not something that completely reshapes what they want to do with their brand, I'll hear it out. I'll bring it to the client. Let's see where we can come to a happy medium. I'm usually going to make that other brand pay for any refilings or anything that needs to be done. And let's move forward. Client still gets what they want. They still get a registration at some point. Even like I said, we may have to make a few tweaks to like something that we had already filed. The other side is backing off. I got that in writing and we're good to go. But every attorney, unfortunately, isn't, like I said, trademark savvy, and they'll fall and be like, well, shit, I don't know what to help. I don't know what to tell you. And I never wanted to be that type of attorney. So I was like, let me make sure my understanding of the law is so solid that I don't have to like hand over somebody that I've been going through this process with for as long as the trademark process takes.
I mean, it makes me think. I mean, one, it's good, especially when you're talking about with smaller brands, because they get the opportunity to make these changes before, we've been doing this for years and years and years, and now we can't adjust on the ship. I'm thinking about those stories about Beyonce and Jay-Z trademarking their kids' names. Like,
they fought for that for 3 years, right?
Yeah.
Because a smaller brand opposed it. So when they was like, she's fighting for the name, she was going through that opposition period.
So I guess my thing is, I'm thinking about names in general, and especially we got a lot of rappers that come on this show. We got a lot of rappers that are on this show, and I think about like the baby, little baby, baby slim, baby dada, or Asian doll this, doll that doll. Like, how does that factor in when you do get these trends of rappers having just the same name with a tweak? And we see what happens with it. So yeah. I always wonder about that.
Because I will say, even as an indie artist or as an up and coming artist, if you have the opportunity to trademark your name, to do so. Because the last thing you want is to be in a situation like Megan was in before they had some type of behind the scenes deal. And I'll touch on that later. Unfortunately, when there are too similar, you may not be able to get the trademark because somebody beat you to the office is going to be confusingly similar. Normally, there's really only maybe about 3 different categories that an artist would file in. There's a category that houses like all streaming-based music. There's a category that houses all other entertainment services. There's music videos, there's live performances. And then the third category is normally anything apparel-based. Because I don't know a single rapper or singer that doesn't sell tour merchandise, especially like when we had tours before, COVID happened. So primarily those are the 3 that I see entertainers file in. Every now and then you may have one do something in like posters or like printed goods. But if you can get one, if you're not saturated like the dolls and the babies, which I don't know how they're going to do that. That's going to be really hard. But if it's a situation where you're not saturated, even if you don't have the big deal yet, do it. And the reason why I say do it is because normally whenever so I've negotiated a few distribution deals and stuff like that for artists. One, also file for an LLC. That way, whenever it comes to any contracting, whoever the distribution group is or the label is, they're not contracting with you individually. They're contracting with your LLC. There's a term for that. Can't think of it right now. I'll have to send it to you. It's a shield to where you're not under any personal contractual liability. They're contracting with your LLC. It's just because at this point, as an artist, even as an athlete, you're not an individual, you're a business. Mm-hmm. So conduct yourself like a business. They're not contracting. You don't ever see anybody contracting with Steve Jobs. They contract with Apple. Okay. So you conduct yourself the exact same way. That's one. Two, get your trademarks before you sign with the big labels, because the few deals that I have looked at, the first clause I look at is the intellectual property ownership clause, because that's going to tell me a lot about this deal. Most deals that I've seen, especially on a larger scale, any intellectual property, we already went over the definition, any copyrights, which copyrights are going to cover all of your music. That's beats, that's lyrics, that's a poetry book, whatever. If you write a novel, that is considered a copyright. Any copyrights or trademarks, even a patent, any IP that you develop while you're under that label, 9 times out of 10, that contract says it belongs to the label. So you're shit out of luck. If something were to happen, they release you, they normally don't release that IP. No. And they normally don't see that. And see, that's the most important part to me is, as an artist, you are bringing the creativity to the table. What do you get to keep? Or what are they trying to keep? So that's why I never read the contract in order. I always go there first. Because if that's not in order, I don't even want to know what the rest of the stuff says. Because normally, like, either right before or right after the IP is going to also tell you the royalty percentages, because royalties deal with copyrights. So that's going to let you know, like, how much are you going to get in ownership when it comes to the actual creation of the music, which again is a copyright. So I'm right there in that little section, because they normally are like right next to each other. That's where I am first, because I want to see what's going on. So just going back to what happened with Megan, and she even came out and said she signed her contract without reading it. Well, the way the contract was written, where the trademarks belonged to her label. So I knew that there was going to be a problem before it aired. There was a problem, because when everything happened and that, like, everything became known that she was having a problem with her label, people were tagging me like, yo, you called this months ago. Yeah. Because I happened to be, and this is how I knew there was going to be a problem. It goes back to the trademarks and my understanding of trademark law. When I pulled up her trademarks for Tina Snow, and that was at the time Hot Girl Summer was like the big phrase.
Yeah.
So Tina Snow, Hot Girl Summer, Megan Thee Stallion, and I think there was like a fourth one. They were all listed as owned by Theory Entertainment. Theory owned 300 owned 1501.
Ah.
So I was like, from a trademark perspective, this is bad, because now she has no ownership in her stage names, all of them, and the little phrases she coined. So if anything were to go left, the label deal probably says that they own the IP. And the thing is, most of the time, the way, I think wording is important, because most of the time the label will say anything created while under agreement or while under the terms of this agreement. So that excludes anything that happened pre-signing. So if you're already coming with trademark registrations, they can't make you assign those over, because that's IP that was created prior to the effective date of the agreement being signed. Yeah. That's why I say get it first, and then that way, anything that happens after, at least you have that piece. But when everything went south with her label, I'm assuming they had some type of like behind the scenes deal, because now all of the trademarks are filed into what looks like her holding company for her trademarks, because it's like Hot Girl Trademarks LLC or something like that. But somebody was like, well, what can she do to get him back? Again, my understanding of trademark law, I said, this is what I would do. I would be like, so they did not file. Whenever you file a trademark that has anybody's name or nickname or initials in it, that person, if they're living, has to sign a consent. And then that consent has to be filed with the trademark office. And it's telling them, I'm consenting to my name, my likeness, my nickname, whatever, being used as a potential registered trademark. Well, when the label rushed to file all of those marks, they never filed her consent with them. So the trademark office sent them initial rejections saying that we need this consent before we push it forward. So if I was her representation, what I told them what I would do is not sign those consent forms. You can't get the registration without the consent. So I'm like, if she was still under the label, I would have been like, you either sign it over to me and then I'll sign the consent, or you make me 50% owner and then I'll sign it. So I'm assuming something like that happened on top of the deal going left, because now they've moved all the ownership over and now the consents have been filed.
Okay. But what happens if she did not take that action or sign the papers? What would they do then?
I mean, they can't force her to sign it.
Okay. But they'd still be able to use like Hot Girl Summer and things of that nature?
I would have to see what the label deal said, but from a trademark perspective, they cannot claim trademark ownership to it because the trademark office will not grant a registration without that consent being signed and on file. So I would have used that as leverage, honestly.
And that's interesting because I think a lot of artists, I mean, including we'll use an example like Megan, you don't think about these things when you're coming up. You're not thinking like, you're like, yo, I'm just trying to get my name out there. Yeah. And that's kind of part of the problem. Your goal in the beginning is, I want to get my name out there popping. And you get it out there, but it's not protected. Mm-hmm. Like, now you're like, okay, I'm out here. Everybody, I mean, and you know, when Hot Girl Summer was, Wendy's was talking about Hot Girl Summer.
Forever 21.
Forever 21. Old Navy. Like, everybody was literally just saying, oh, this is Hot Girl Summer. This is a girl that doesn't have a record deal yet. You know what I mean? Like,
she blew up. Like, for those of us who were in Houston, like, we were hearing whispers of Megan, but then she hit that mainstream and took off quick.
And so I guess that's the thing, where you want to protect yourself, like that is the possibility. I mean, everybody wants to blow up like that, but they're also not protecting themselves as though they might blow up. Because when you look back, that's the kind of stuff you want to own. And you see, I mean, we've all seen the movies, the behind the scenes stories, the documentaries where the label's prepared. Like, you know, you see so many artists where they're like, man, the label own me.
Everything.
Like, they own my name. Like, I can't use my own name.
Yeah.
So, like, I was like, you know, have some faith in your abilities. The way, look, whether the label believe in you or not, they sure did sign all of your stuff. Like, they were like, yo, we're going to get you some money, but we want to own all of this. And people really don't understand what they're signing away when they do these things.
That's why I always say, and not even me, but if they don't allow you the opportunity to have independent, the key word is independent counsel.
So not they lawyer. Like,
man, you know how many times I'm like, nah, let me say something. Why would their lawyer look out for your best interest? Yeah. Just make that make sense.
It's like a Diddy and the band situation where they're like, hey man, Diddy got us lawyers. And I was like, Diddy.
I'm like, no. Diddy got him more lawyers. Like that, those aren't for y'all. So in situations like that, I at least try to tell artists, like, seek independent counsel before you sign anything. Legally, if there's an attorney on the other side, and there always is an attorney on the other side, especially dealing with a label, they have an ethical right to allow you to seek independent counsel before signing anything that will make you bound to it legally. And if they do not allow you that opportunity, that's a red flag.
Yeah.
And for more than one reason.
And just have some faith in the idea that you can. We talk to so many artists that are like, yeah, they said I could get an attorney, but they were also like, but we need to get this signed like right now. And I'm like,
ain't no but. Like, do I get an attorney or not?
Like, I was like, yeah, so it's never like, don't feel the pressure. I guess my biggest thing too is when we're talking to artists is, if they are offering you anything, you have value. Like at that point, like respect the fact that you have value. And if somebody is trying to get, nobody is trying to give you their best offer up front. That's just people. Like nobody's gonna be like, let me give you my best offer right now. For the 9 times out of 10, they like, I'm gonna try to undercut this person and try to get what I can right now. So yeah, you do have a lot of artists that are like, yo, I just felt like I really couldn't go ask anybody.
No, you have the time. I don't believe ain't nothing to rush unless you have in cardiac arrest. So, I'm just like that contract ain't nothing gonna happen with that contract in 48, 72 hours. Like they need to give you time because you're gonna be, and most of them aren't like a 30-day contract. Some of them can be a few years. So you want to make sure that you thoroughly understand it. And I'll say too, make sure you have an attorney that's able to explain the terms to you in a way you can understand. Because I think one of my biggest pet peeves is my constituents that like to use overly large words like I just did.
Yeah.
Instead of just explaining a concept, like just explain it to me. Because I had a young lady I had a consultation with who said I was probably like the 4th attorney she spoke to. And she was like, you're the only one that I have spoken to where I understand. And I told her a big thing for me, and this practice happened back in law school. I felt like while I was studying for my exams, if I couldn't explain a concept to my mom or to, who has no legal background, I was the first attorney in my family. So if I can't explain these concepts to someone without a legal background and they understand it, then I don't know it well.
That's good because I mean that brings up. I mean, I think that was Cardi B that was saying like, I talk to my attorneys, and if they cannot explain every line of everything, what I mean. There was one person I was talking to, attorney, and was like, look, if you're on the other side and they can't explain a line, then just scratch it out. Like I said, he goes, this must not be important to y'all. And he goes, and you will see how very quickly they'll be like, oh, well, no, that's important. So it's like, oh, well, just explain it to me. So I really love when Cardi B was saying, like, find an attorney that's going to explain it out to you. And I like that we have people out there like you that's doing that. Because legalese is big. Like,
and I tell people, I said, if you include English, I speak 4 languages. And they're like, 4? I'm like, English, Spanish, French, legalese. That's 4. Like, I speak 4.
And people don't realize the uphill battle when it comes, especially recording contracts.
Oh,
and record label contracts. I said
the worst things
I think there was Rory on Joe Budden podcast that was like, you can't even read your cell phone contract. And I was like, that there are a lot of contracts that we sign.
You don't read the terms and conditions from Apple before you hit accept.
I was explaining to somebody, I said, like, a lot of these streaming services, you signed up for stuff and you don't own it. They can take that stuff down. They can take albums right away from you. That you feel like, yo, I own this, I paid for it.
Ads. You signed up for that.
That's it. So that's a big thing. Well, first of all, we only said we keep you here for an hour. I feel like we could talk to you for like 2, 3.
You really can.
I run my mouth. I'm sorry.
This is good.
No. This is great.
Do part 2, y'all let me know.
Oh no, we'll definitely be doing.
Definitely will.
Before we even get into the part 2, though, I mean, let people know. Because I have a feeling a lot of people are going to want to know where to find you and how they can get in contact with you if they're interested in any of your work and legal work and things like
that. Social media is going to be the easiest, honestly, because normally from there, like I treat DMs like emails. So from there, I'll usually pass on the rest of my information. But you can follow me on Instagram and Twitter at Jovant, that's JOB as in Victor, ANT_GARDE. And it's a play off of the term avant-garde, but somebody took it. So I just added the first 2 initials of my name. Jovant is not my name. My name is Jordan. I get that all the time. But yeah, so Jovant_guard. You can follow me there, or I'll just give my email too. It's jfranklin at K as in kite, M as in Mary, D as in dog, 20 at gmail.com. And it's a play off of the term avant-garde, but somebody took it. So I just added the first 2 initials of my name, Jovant is not my name. My name is Jordan.
There you go.
.law. .law.
There you go. There you
I was like, it's somewhere.
She was a
KMD.law. Yeah, I was. The camera is like opposite. So.
I know. I've done it many times. It takes a second to get used to it.
Yeah, that's my direct email. So either way works.
Oh, okay, that's perfect. That's perfect.
Well, that was awesome. We really want to thank you for coming by.
Oh, I had a good time.
That was pretty awesome. We're gonna have to have a part 2. I hope everybody learned something today because I definitely did. There's so much that I don't know about law. It could feel like a law library. You stepped on my joke. Thank you, brother.
My bad.
But it is what it is. Once again, this has been In My Humble Opinion podcast. I've been Avery Like a Very Nice Guy, and this has been my brother, Jess Devon.
Hi.
I don't know why he does it like that. It's so dry.
Yeah, that's because I'm Jess Devon.
Because he's Jess Devon. It's so cute. If you want to be a part of the Humble Hive, you've got to like, share, and subscribe. Humbly yours, In My Humble Opinion podcast. Thank you and good night. H-Town's too sweet. H-Town's too sweet.
You should trademark